Mishcon Academy digital sessions.
Okay, well, welcome everyone, and thank you for joining this Mishcon Academy session, part of a series of online events, videos, and podcasts looking at the biggest issues faced by businesses and individuals today. I am Sian Harding, and I will be hosting today's event. So I am very excited to introduce my guest today, Professor Ryan Abbott. Ryan is a professor of law and health sciences at the University of Surrey School of Law and adjunct assistant professor of medicine at the Geffen School of Medicine at UCLA. He is also a CEDR accredited mediator and a fellow of the Chartered Institute of Arbitrators. He is a licensed physician, patent attorney, an acupuncturist in the US, and a solicitor advocate in England and Wales. Thank you so much, Ryan, for joining me today.
Thanks so much for having me. Very excited to be here.
Thanks. So we're going to be talking about AI and the law and how we should approach the regulation of AI. So this is a topic of your book, The Reasonable Robot. So Ryan, you are a lawyer, you're a physician, you've written a book about AI and the law. Where does your interest in AI come from? What brought you to write the book?
Well, I think my interest in AI academically came about in about 2013, 2014, when I was working as a patent attorney for a biotech company and teaching inventorship law at law school. And there were vendors who were basically advertising that you could have them do things like have machines go through large antibody libraries and pick out an antibody that went to whatever antigen you were studying. And it got me thinking that, that's interesting because if we have a person do that sort of thing, it makes them a patent inventor. So what if a machine does that? And academics had kind of said, well, you really wouldn't need a patent for that because a machine doesn't care about a patent. And I thought, well, that's clearly right. But on the other hand, the pharma companies that are building the AI and having the AI do this work need patents. So maybe that's not the right answer. And that sort of set me off on a quest, kind of looking at ways in which machines do human sorts of things, but the law treats those behaviors very differently.
Before we get into the substance of your book, why don't we just, first of all, establish what we're talking about when we talk about AI, just so that everyone's on equal footing?
And it's kind of sociologically fascinating if you think about it, that in 60 years since we've been using the term AI, people still aren't talking about the same thing. Some people define AI, based on how someone is making an AI, as in, for example, machine learning versus conventional software. Personally, I don't think that's the right way to go about it. I think about it very functionally. An AI is basically a machine that behaves, the way a person does, or in a way that you would describe cognitive abilities to a machine. And for me, that's important because what we're really looking at with law and regulation is, what rules will best promote social well-being. And that really comes down to what is it we're having machines do, not how are they structured.
So the principle that you propose in your book as to how we approach those issues is the principle of AI legal neutrality. Could you talk to us a bit about what this is, what its aims are?
You can have a machine-generated invention or a person-generated invention, and the law will treat those two activities very differently in terms of, for example, subsistence of intellectual property rights. In a few years, we'll have self-driving Ubers, hopefully, and you'll be on your phone able to summon a self-driving or a human-driven Uber. But if, one or the other of those causes the same exact sort of accident, doing exactly the same sort of thing, the law treats those behaviors very differently. Or if Mishcon is able to replace you with a robot, the tax consequences of that are very different. And University of Surrey is constantly trying to replace me with a robot. So the book is noticing that the law treats behaviors very differently by people and machines and finds that it tends to have negative consequences. And so the book proposes that even though we don't treat AI and people the same as legal actors, that we treat their behavior functionally equivalently under the law.
Why, in your view, is it important that AI can be acknowledged as an inventor, and why is this not already a thing?
The two reasons it's important are, one, the subsistence question, which is the commercially important question. Can I get a patent for this sort of thing, right? You don't want Pfizer investing $100 million in building an AI to find new COVID antibodies to then say, well, sorry, no patents for you, right? And then secondly, there's sort of the moral issue of, well, who should be listed on the patent? If I own an AI that invents a whole bunch of stuff, should I get to say, oh, that was me, even if I haven't done anything involving inventive skill? And we'd answer no.
You've been involved in this kind of multi-jurisdictional attempt to have an AI machine recognized as an inventor in patent applications. I believe it's known as Davos, or less catchy, device for autonomous bootstrapping of unified sentience. Can you tell us about these test cases? What is Davos? What are you trying to do?
So we filed 2 test cases for 2 AI-generated inventions. One's a fancy beverage container, and one is a flashing light that could attract attention in an emergency situation. We filed these in the UK and in Europe because we got expedited examinations, and they were found to be substantively patentable. And then we corrected it and said, well, actually, there was no human inventor, an AI invented this, and the person who owns the AI should own the invention. And those applications were rejected from the UK and Europe, and we filed them in 15 other jurisdictions. In July of last year, South Africa granted us a patent. That was the first patent for an AI-generated invention. South Africa doesn't have a substantive examination system, but they do formalities examination. And everywhere we'd been rejected, it was on a formalities basis. So we got that patent. And 3 days later, Justice Beach in the Federal Court of Australia ruled that was the appropriate way to handle this, that there's no reason that as a matter of fact, an AI couldn't be listed as an inventor. And at least in our case, the AI's owner had the clearest claim of entitlement to it. That decision is under appeal. Next week, there will be a hearing before 5 members of the Federal Court of Australia. We've also been rejected in the US, the UK, Europe, and Germany. All of those are under appeal. The benchmark for getting a patent is based on what this hypothetical skilled person would find obvious, which is like the reasonable person in tort law. And that person is explicitly not based on what an inventor would find obvious, because inventors would find almost everything obvious. But the skilled person over time has sometimes become a skilled team of people in industries where team-based approaches to invention are the norm. Well, I think it's probably already the case that the skilled person today is often the skilled person using an AI. And that makes more obvious, because using AI can help people do things they couldn't do otherwise, like recognize patterns in large data sets, or have access to superhuman amounts of prior art in a way that's actually useful to people.
And so you also mentioned in your book the risk that developments in AI may result in a large number of patents in the hands of a small number of companies, and that can lead to potentially competition issues, market abuses. Is there anything we can do or that we should do to mitigate that situation now?
So that's an interesting, aspect of this, and about AI activity more generally. I mean, it's hard to know. For example, Davos is owned by a small business in the Midwest in the United States, but probably large businesses are going to have significant advantages when it comes to making and building these AIs. And if they are as productive as they're hoped to be, it may result in a lot more consolidation of intellectual property in their hands. I would first note that is, for better or worse, the way we've organized our society and our IP system, and that most patents are owned by large businesses and by a fairly small number of large businesses. And, that's how we generate innovation more than the romantic version of an inventor who's tinkering in her garage late at night. Say Facebook I should use Facebook. We'll use Facebook, has an AI that you presented a tissue sample from a patient. It goes through a trillion antibody library and it 3D prints an antibody to treat their cancer. And thus Facebook invents the cure for cancer. And, it puts every other cancer researcher and treatment out of business. I still think that's a pretty good outcome, because we've cured cancer. And if, people are price gouging or not making access available, there are things one can do under competition law, or have things like compulsory licenses, and maybe that will be the time to finally start invoking some of those things a little more aggressively.
And so you mentioned briefly taxes there. And so if we can just dive into that a little bit. In a world where kind of AI is starting to do the revenue generating jobs that humans have historically always done, you suggest in your book that the tax system needs to be adjusted to make room for this, and to ensure that companies aren't financially incentivized to use AI instead of humans, where it otherwise isn't necessarily beneficial. So can you talk us through that and tell us what a better tax system looks like in your view?
Sure. So if we go back to the example of Surrey replacing me with a robot, there's a lot of reasons Surrey might want or might not want to do that. But one of the reasons that, hasn't been that widely appreciated is if they could automate me, excuse me, they don't have to make national insurance contributions for the work done by a robot. And so without necessarily having intended to, the tax system encourages employers to automate, even if it isn't otherwise more efficient, if it's somewhat of a close call. The other underappreciated effect of this is that almost all government tax revenue, at least in the United States, comes from labor income in one way, shape, or form. Less than 10% of revenue comes from corporate taxes. It's almost all from income taxes and from payroll taxes in the United States. And so if I get replaced by a robot, the government loses a significant amount of tax revenue.
So you look quite extensively in your book at tort law and tort liability and how we might approach that in the case of AI. So in tort law, liability is based fundamentally in there being a duty of care. Can we impose a duty of care on an AI robot? How might we do this?
You could create a system where they have the legal obligations not to cause harm and insurance policies or some form of security and so forth. But again, I think it just works much better in terms of ultimate liability to treat them as products. I mean, they are ultimately almost all going to be commercial products, and two of the areas where I think we're going to see a lot of this are self-driving cars, which, are almost with us or, moderately with us already, just not fully self-driving, and AI being used to replace in some sense physicians doing some things like diagnosing scans and pathology slides. But right now, if you have, let's say you have a physician who misses a cancerous mole and an AI app that misses a cancerous mole. They're both doing exactly the same thing, but the human physician will be held to a negligence standard and will say, well, what would a reasonable doctor have missed? Whereas with the AI, though it differs a bit by jurisdiction, in the US, we'd say, was there a defect with the product or with its marketing? And if there was, regardless of the presence of reasonable care, there's liability. And strict liability is largely held to be a stronger, standard of liability for the AI. But I think it doesn't make a lot of sense to have two agents doing exactly the same sort of thing, one held to a higher standard of care. And the reason is that will, discourage people from using it. And we want people to use it if it's safer than a physician. And so essentially, if we had a uniform standard of care and said, what would a reasonable physician have missed? And if the AI outperformed the human physician, the manufacturer of the AI would not be liable for a mistake that it made. So that would have the benefit of promoting use of technologies that are safer than the current standard.
And I mean, how can clients approach that? Is there a way we can regulate to make sure AI is as transparent and trustworthy as possible? Or is it kind of just going to be in each specific use case, the person who has the AI or is using it needs to just be really careful and make sure they understand what the AI does, why it does it?
Well, a bit of both. I mean, firstly, I would say there are a number of regulations that already come into bear here, in requiring AI transparency, even though there aren't AI specific regulations yet in the UK. And I suspect we will see them as we will see them in Europe in some way, shape, or form when these AI regulations, presumably finally enter into force, with some changes. But I would say for Mishcon lawyers that, now is the time to be working with clients on these sorts of things, even if there aren't, AI specific regulations, because there are already, compliance risks under existing regulations, but also, very importantly, risks related to public opinion and investors and, of bad regulatory rules coming down in response to some sort of adverse actions. And how one does that, I do think it has to be very well informed and very context specific. If you are having, an AI that's diagnosing cancerous moles, maybe a machine learning version gets 99% accurate and a conventional AI gets 65% accurate. And you end up deciding, I'm going to sacrifice transparency for accuracy, but I've done so in a very calculated way, because that has the right outcome. If you have an AI that's, hiring people from reviewing CVs, but can't tell you why it selected someone, maybe that's somewhere you don't want where transparency is one of the most important things you can get, in part because there aren't necessarily objectively right answers to, should candidate A or B get hired, but there are some objectively wrong ones like, well, I've decided that I don't like, this category of person, so I'm not going to select their job applications, and then how one does that technically is having, a multidisciplinary group of people advising on this. But there's a lot one can do if clients are kind of aware of the risks in this space and have someone who can help guide them to solutions.
It's a fascinating area of law. I mean, there's so many sort of aspects of AI to think about and so many uses that need to be thought about and different approaches to regulation taken. I think probably that's all we're going to have time for. I'm sorry to the people who are asking questions. But thank you so much, Ryan, for joining us. It's fascinating. I really enjoyed your book. And yeah, thank you very much.
So, thanks so much. And happy to chat with anyone anytime if you'd like to reach out.
Thanks so much, Ryan.
All right. Cheers.
The Mishcon Academy Digital Sessions. To access advice for businesses that is regularly updated, please visit mishcon.com.